Welcome to Module 2 of our training, focusing on GDPR foundations, core principles, and lawful bases. In this module, we will explore the foundational requirements of the General Data Protection Regulation, starting with an executive summary of the most critical articles. Our focus is on GDPR and other international privacy laws, aligning with ISO standards 27701 and 27018 and mapping national laws. We are specifically diving into Article 5, which outlines the core principles of processing, and Article 6, the lawfulness of processing. Article 5 establishes 7 foundational principles. Controllers must comply with these, and importantly, must be able to demonstrate compliance, known as accountability. The first principle is lawfulness, fairness, and transparency. Processing must have a lawful basis, and individuals must clearly understand what data is collected, why, and how it is used. Hidden processing violates this. Purpose limitation means data must be collected for specified, legitimate purposes. Data minimization requires collecting only data strictly necessary for that purpose. Excessive data increases legal risk. Accuracy mandates that personal data must be kept up to date and corrected promptly. Storage limitation means data cannot be retained longer than necessary, requiring defined retention periods and deletion mechanisms. Integrity and confidentiality, or security, requires appropriate technical and organizational measures to protect data against unauthorized access, loss, or damage. This includes robust encryption and access controls. The final principle is accountability. Controllers must document compliance through policies, records of processing activities, risk assessments, and continuous audit trails. Article 6 is the gateway to lawful processing. No processing is permitted unless at least one of the 6 valid legal bases is identified, documented, and communicated to the data subject. Consent must be specific, informed, and freely given. Contract processing is strictly necessary to fulfill an agreement or take pre-contractual steps. Marketing, however, requires a separate basis. Legal obligation applies when processing is required by law, such as tax reporting. Vital interests are reserved only for genuine life or death emergencies, where consent is impossible to obtain. The public task or official authority basis applies to public bodies performing legally mandated public functions, and the task must be grounded in law. Legitimate interests is flexible but complex. It requires a documented legitimate interests assessment, or LIA, using 3 tests: purpose, necessity, and a crucial balancing test of rights versus interest. Processing without a valid lawful basis is a serious infringement. Penalties can reach 20 million euros or 4% of global turnover. Data collected for one purpose cannot automatically be reused for another. Compatibility must be assessed, considering the link between purposes, context, data sensitivity, and implemented safeguards. Data protection officers must identify and document the lawful basis in the Article 30 ROPA, communicate it in privacy notices, conduct LIAs, and ensure staff training. Controllers must always be able to demonstrate compliance through rigorous documentation, policies, and audits to avoid severe accountability penalties. The key takeaway is that GDPR compliance starts not with technology, but with Article 5 setting the framework and Article 6 determining whether your processing is lawful at all.